So remember when we said the Trump administration snatched an unknown number of immigrants from the streets of America without any due process, no hearings, no trials, and renditioned them off to detention centers in Trump-friendly jurisdictions, then sent them on flights to a Salvadoran torture prison where they will be placed under the watchful eye of the guy who describes himself as the coolest dictator in the world? Well, we have an update. Things have gotten worse. Things have gotten much, much worse. And honestly, despite everything that's happening in the world, I think this ought to be the most important news story in the country. Now, these actions triggered a wave of lawsuits that we previously covered. Then at the 11th hour, Judge Boasberg swooped in to save the day, ordering the government to turn the planes around. Then the government thumbed its nose at the order and continued to send people to the gulag with zero opportunity for due process, while simultaneously declaring that their inability to do so was an emergency worthy of a stay by the DC Circuit Court and eventually the Supreme Court. Now, this broke with 249 years of American legal precedent, and this could very well be the beginning of the end of one of our country's founding legal principles, the right to due process. None of the individuals detained have ever been found guilty of any crime, nor were any of them charged with one. In fact, most of them were on the government's radar because they were attempting to go through the US immigration system the legal way, via immigration courts. And yet Donald Trump has appointed himself their judge, jury, and executioner.
They emptied jails out. Other nations emptied their jails into the United States. That's an invasion. And these are criminals, many, many criminals. Murderers, drug dealers at the highest level, drug lords, people from mental institutions. That's an invasion.
Whether citizen or not, anyone detained by the US is entitled to due process as a constitutional right. But those rights are in question now. So first, a quick refresher of the facts, horrifying as they are. The named plaintiffs, identified only by their initials, are a group of 5 Venezuelan nationals who are being detained by the government. The lead plaintiff, JGG, arrived in the United States in March of 2024 and sought asylum. According to his court filings, he fled Venezuela because he had been tortured, arbitrarily imprisoned, and beaten by the Venezuelan police, whom he claimed will continue to retaliate against him because his stepfather is a political dissident. Like many of the other plaintiffs in this case, JGG was already going through the legal steps of the immigration process. He even had a hearing scheduled regarding his asylum application. And I will remind you, asylum is legal immigration. And while it may or may not be true that everything he has alleged is true, that's the purpose of the asylum process, to determine if it's true, and if it is, at the end of that process, he would be granted asylum and would be a legal resident in the United States. Apparently, though, that process was moving too slowly for the Trump administration because instead of waiting for the immigration system to properly adjudicate JGG's asylum case by doing, inefficient things like evaluating evidence, allowing him to have a hearing, and requiring adjudication by a neutral third party, the administration detained him and then presented JGG, a native Spanish speaker, with papers in English while falsely claiming that he was going to be released. Once he signed those papers under that false pretense, the government whisked him away to a detention center in Texas. At 3 o'clock in the morning on March 14th, 2025, he was awakened by the guards and told that he was going to be transferred somewhere else. The guards refused to specify where he was going to be sent or why. That transfer was apparently thwarted by a mechanical problem with the plane, which allowed JGG to contact his attorney and file this lawsuit on the morning of March 15th. And I will also remind you that the plaintiffs were not seeking full residency in the United States. They were simply asking for regular due process and to let the process of the immigration courts play out. But in their lawsuit, plaintiffs stated that they had heard that the Trump administration planned to invoke the Alien Enemies Act to remove Venezuelans to El Salvador's notorious prison, the Terrorism Confinement Center. And as we've discussed before, the Alien Enemies Act is a 1798 law that was designed to give the president sweeping power to expel immigrants in times of war, and it has rarely been invoked since. And to be clear, when I say that El Salvador's Terrorism Confinement Center is a torture prison, I'm not exaggerating. The BBC published a shocking expose on the prison in 2023, highlighting its various human rights abuses, which included overcrowding, no windows, fans, or air conditioners to combat the year-round tropical heat, no outside recreation, and no familial visitation. Salvadoran officials have proclaimed that they don't expect the prisoners will ever be released. According to court filings, police beat newcomers to the prison with batons, prisoners are sent to dark basement cells where they're beaten daily, and one prisoner even required an operation for a ruptured pancreas and spleen. Scholars have stated that 375 detainees have died in Bukele's Salvadoran gulags, but some estimate that the number is more than 1,000. So upon hearing that the president was about to invoke the Alien Enemies Act to send them to a torture prison, the plaintiffs understandably were terrified and implored the DC District Court to issue a TRO preventing them from being extraordinarily renditioned to El Salvador based on the groundless whims of the Trump administration. And later that same day, the Trump administration confirmed the rumors by issuing a proclamation declaring that it was invoking the Alien Enemies Act to apprehend, detain, and remove members of the Tren de Aragua gang, a violent Venezuelan gang that has been designated as a terrorist organization. is staging an invasion or predatory incursion on behalf of or in collaboration with Venezuela's dictator Nicolas Maduro. Now, if you think that seems a bit of a stretch, I'm with you, and we'll get to that in a bit. But the government has claimed that JGG and the rest of the plaintiffs are being renditioned because they are members of Tren de Aragua. The plaintiffs have all argued that this is not true. Several plaintiffs have pointed out that the government's suspicions are based on the specious fact that they have tattoos, including a tattoo of an eye and a tattoo of a rose and a skull. The government has provided no evidence to support this assertion that any of the members are in fact members of Tren de Aragua. Now, in ordinary times, there are actual processes for adjudicating these kinds of questions of fact, and they're called courts. This is why courts exist. If the administration wanted to credibly accuse the plaintiffs of membership in Tren de Aragua, they could have pursued criminal charges or allowed plaintiffs to continue to work their way through the immigration system. But instead of gathering evidence and laying out a case against the plaintiffs, the Trump administration just stamped them with the terrorist gang members designation and sent them for an indefinite stay in a Salvadoran gulag. DC District Court Judge Boasberg came in on March 15th by issuing a TRO from removing any of the individual plaintiffs from the United States for 14 days. Judge Boasberg also provisionally certified a larger class of plaintiffs, specifying that all non-citizens in U.S. custody who are subject to Trump's proclamation also could not be removed for 14 days. And in the March 15th hearing, Judge Boasberg told the Trump administration's attorney that, quote, "You shall inform your clients of the order immediately, and that any plane containing members of the class that is going to take off or is in the air needs to be returned to the United States." As Judge Boasberg later pointed out, his orders were quite narrow. He said, quote, "Neither order required the government to release a single individual from its custody. Neither order prevented the government from apprehending anyone pursuant to the just published proclamation, and neither order prevented the government from deporting anyone, including plaintiffs, through authorities other than the proclamation, such as the Immigration and Nationality Act." And indeed, as the plaintiff last month designated Tren de Aragua a foreign terrorist organization, members of that gang are already inadmissible to, and thus deportable from, the United States under the Immigration and Nationality Act. Now, the Trump administration, desperate to avoid having to actually present evidence before indefinitely detaining people in a torture prison, filed an appeal to the DC Circuit that same day. In the meantime, while the Circuit Court appeal was pending, the Trump administration decided to continue renditioning people out of the U.S. in contravention of Judge Boasberg's March 15th TRO. According to the government's own statements, 2 planes left prior to Judge Boasberg's ruling and would have been in the air and thus still subject to his order at the time that the order was issued. Indeed, the administration bragged about his continued non-compliance, declaring on March 31st, after Judge Boasberg had extended the TRO until April 12th, that, quote, "Last night in a successful counterterrorism operation with our allies in El Salvador, the United States military transferred a group of 17 violent criminals from the Tren de Aragua and MS-13 organizations, including murderers and rapists." So on March 16th, Judge Boasberg set another hearing to discuss the Trump administration's non-compliance, and the administration filed a motion to vacate the hearing, arguing that the court lacks jurisdiction to, quote, "interfere with the president's national security and foreign affairs authority," led by Pam Bondi. Trump's Department of Justice had the temerity to argue that because Judge Boasberg's more specific order to turn those planes around was issued orally, it wasn't actually an order. It was really more of a suggestion. Yes, that's what they actually argued in court. Judge Boasberg was apparently unimpressed with the administration's legal wrangling because he held the hearing anyway and ordered the government to submit sworn declarations certifying that no one on any flight departing after the TRO was issued had been removed solely on the basis of the Alien Enemies Act. He also ordered the Trump administration to specify when the proclamation was signed, made public, and went into effect, and how many individuals subject to the proclamation are still in the U.S. and in U.S. custody. The administration responded that it didn't think that it needed to answer the judge's questions about the flights, but that if it must answer those questions, it will only do so in camera or with an ex-parte declaration, meaning that they would only do it in the judge's chambers outside of the eyes of anyone else. Now that was strange because the administration had broadly publicized many details of these renditions. Bukele himself had posted on Twitter on March 16th stating, quote, "Today, the first 238 members of the Venezuelan criminal organization Tren de Aragua arrived in our country. They were immediately transferred to SCOTUS, the Terrorism Confinement Center, for a period of 1 year, renewable. The United States will pay a very low fee for them, but a high one for us." Bukele also bragged about how the prisoners in SCOTUS are being used as slave labor, stating, quote, "Over time, these actions, combined with the production already being generated by more than 40,000 inmates engaged in various workshops and labor under the Zero Idleness program, will make our prison system self-sustainable." In response to these declarations, Secretary of State Marco Rubio replied on Twitter, quote, "Thank you for your assistance and friendship, President Bukele." So it was clear that the administration wasn't exactly keeping this a secret, and it was odd that they would argue to the court that this was super sensitive information. Judge Boasberg, though, generously allowed the administration to file its answers ex parte and under seal. But this was still not good enough for the Trump administration, which decided that it didn't want to answer the judge's questions at all, and instead filed a motion to stay the judge's order to disclose details about the flights, claiming that, quote, the court's continued intrusions into the prerogatives of the executive branch, especially on a non-legal and factually irrelevant matter, should end. Defendants whinged about the court's, quote, micromanaged and unnecessary judicial fishing expeditions, and claimed that, quote, there is no serious dispute that the government complied with the minute order. But the Trump administration argued that it needed the stay because it was evaluating whether to invoke the state secret privilege to portions of the information the court was seeking, and that a stay was warranted while the appeal to the DC Circuit was pending. Defendants also threw in a few arguments about how the invocation of the Alien Enemies Act wasn't reviewable by the court, and, just to add insult to injury, stated outright that they did not trust Judge Boasberg to not share the ex parte information with the plaintiffs, stating, quote, the government does not currently have any assurance at this time that information provided to the court on an ex parte basis would not subsequently be provided to the plaintiffs or the general public before the government could seek appellate review of that further disclosure. But Judge Boasberg was not having it. He granted the government an additional day to provide the information, but sternly called defendants out in their non-compliance, stating, quote, to begin, the court seeks this information not as micromanaged and unnecessary judicial fishing expedition, but to determine if the government deliberately flouted its orders issued on March 15th, 2025, and if so, what the consequences should be. And Judge Boasberg expressed surprise at the government's claims of secrecy and referenced Secretary Rubio's post on Twitter, proudly sharing details about the plane's arrival in El Salvador. The judge also blasted the administration for appearing to flout his order, stating, quote, as the Supreme Court has made crystal clear, the proper recourse for a party subject to an injunction it believes is legally flawed, and is indeed later shown to be so flawed, is appellate review, not disobedience. So while the fight over disclosing the flight details was ongoing, the administration also moved to vacate the temporary restraining order, arguing that Judge Boasberg had no jurisdiction over the case and that the plaintiffs had not satisfied the TRO requirements. Judge Boasberg declined to vacate the TRO and rejected the Trump administration's arguments that he could not consider the case, finding that, quote, the court need not resolve the thorny question of whether the judiciary has the authority to assess this claim in the first place. That is because plaintiffs are likely to succeed on another equally fundamental theory. Before they may be deported, they are entitled to individualized hearings to determine whether the act applies to them at all. Judge Boasberg declared that the named plaintiffs and their larger class of plaintiffs may not be deported until their due process rights are vindicated and they've had their day in court. Now, the Trump administration's appeal to the DC Circuit Court of Appeals is even more extraordinary than the temporary restraining order that inspired it. We've talked on plenty of occasions about TROs in the past few months because there have been a lot of them, but just to reemphasize it again, TROs, temporary restraining orders, are an extraordinary temporary remedy. They are typically unappealable in large part because they are meant to be temporary and short-term. Judge Boasberg's first TRO in this case was a 14-day TRO, and that was extended until April 12th. But TROs are only designed to provide temporary relief while the court adjudicates the underlying claims. And typically, if a party doesn't like the terms of the TRO, they just have to wait out the adjudication on the merits, which is what the Trump administration could have done here. But it's worth noting that, again, Judge Boasberg didn't order the administration to release the plaintiffs. He didn't order the administration to stop moving forward with the deportations for members of the Trinidad gang under the Immigration and Nationality Act, and he didn't even order the administration not to deport these particular plaintiffs under the act. He just said that until April 12th, the administration couldn't continue to rendition people without due process based solely on a specious interpretation of the Alien Enemies Act. That's it. So all the administration had to do was either to continue the lawful immigration deportation proceedings that are permitted under the Immigration and Nationality Act, or wait until the court adjudicated the alien enemies questions. But the second Trump administration seems committed to doing everything immediately with no oversight or legal process. Now, the administration conceded in its emergency motion that TROs are usually unappealable, but argued that this one was such an egregious imposition of the president's authority that it really should be treated like a preliminary injunction, which is appealable. The administration claimed that even the short delay in the removals that the TRO created would create nationwide harm. It offered no real arguments about what harm would be posed by this delay, especially since Judge Boasberg's order expressly allows the government to continue to detain any potential members of Trinidad. So it's not like the judge ordered that a bunch of violent criminals be released out into the street. But the administration also doubled down on its unsupported accusations that the plaintiffs are dangerous terrorist gang members and argued that Judge Boasberg had overstepped his authority by imposing on the executive branch's power to remove them. And the Trump administration also argued that the court lacks authority to review actions under the Alien Enemies Act, stating that the law, quote, confers unreviewable power in the president. So let's break that down. According to the defendants, the courts have limited review powers related to the Alien Enemies Act because the invocation of the Alien Enemies Act relies on a political question, and political questions must be left to the president. Courts can only review the construction and validity of the statute, whether there is a declared war, if that's the provision the proclamation rests on, and whether the person restrained is an enemy alien 14 years or older. But the administration also concedes that there is no officially declared war against Trinidad or Venezuela. Instead, it argues that the requirements of the Alien Enemies Act were satisfied because Trinidad's presence in the United States is either an invasion or a predatory incursion. The only authority it cites to support the idea that Trinidad is involved in an invasion under the Alien Enemies Act is, I'm not kidding, Black's Law Dictionary, which ought to send shivers down the spine of every lawyer because basically that's a concession that there is no case law that supports your proposition. And its argument that this was a, quote, predatory incursion for the purposes of the Alien Enemies Act are similarly thin, citing two cases that don't appear to relate to the Alien Enemies Act. And even if there was a broadly defined invasion or predatory incursion under the Alien Enemies Act, that invasion or predatory incursion must be, quote, perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government. So a regular old criminal gang won't qualify. And in order to invoke the act, the president needs to demonstrate that the criminal gang is actually acting on behalf of a foreign nation or government. In its motion, the administration claimed that Trinidad is, quote, backed by the illegitimate regime of Venezuelan dictator Nicolas Maduro, and that Trinidad is, quote, closely aligned with and has infiltrated Maduro's regime. But the only evidence the administration offered to back its claims that Trinidad is intertwined with the government of Venezuela are citations to Trump's own proclamation. That proclamation, of course, offers no factual support for these claims, and the proclamation's only proof of a Maduro-Trinidad collaboration is a 2020 accusation leveled by the previous Trump administration, but that had nothing to do with Trinidad. Instead, in 2020, the Trump administration accused Maduro of allowing Colombian narcotic traffickers to fly cocaine through Venezuelan airspace, which is, again, entirely unrelated to Trinidad. So the administration concedes that there is no actual war and offers little evidence that there is an invasion or predatory incursion sufficient to trigger the Alien Enemies Act. The administration also boldly claimed that, quote, plaintiffs would not necessarily be irreparably injured by removal. This argument seems particularly ridiculous in light of the administration's assertions that it cannot retrieve Kilmar Abrego Garcia, the Maryland man who the administration conceded was sent to a torture prison because of an administrative error. So basically, if someone is wrongly sent to a torture prison, the government's position is that it can't get them back. Or as Bukele said, oopsie, too late. So that harm to me seems pretty damn irreparable. Now, if you are abducting migrants and you're not the US government, you'll probably want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need the legal team, you need the Eagle Team. And unsurprisingly, the DC Circuit found the administration's arguments unpersuasive. DC Circuit Court Judge Karen Henderson, nominated by President George H.W. Bush, began her ruling by dealing with the question of whether the TRO is appealable in this case. She found that in this case, because the plaintiffs had sued the president specifically, the TRO was uniquely suspect. As Judge Henderson points out, quote, equity has no jurisdiction to enjoin the president in the performance of his official duties, and although injunctions against executive officials are routine and proper, injunctive relief against the president himself is extraordinary and should raise judicial eyebrows. The uniqueness of the situation, in Judge Henderson's opinion, merited the court exercise unusual jurisdiction over the TRO. And having dispensed with the threshold question of whether or not the circuit court could consider the TRO, Judge Henderson went on to consider the factors governing whether a stay should be granted. Now, the factors governing whether to stay a lower court's order are very similar to the factors for a TRO. And Judge Henderson determined that the Trump administration was unlikely to meet the first factor because it probably would not prevail on the merits of the case. Judge Henderson first rejected the political question doctrine. The Trump administration argued that the question of whether or not Trinidad's presence in the United States qualifies as an invasion or predatory incursion is ultimately a political question, and thus the courts can't review it. But Judge Henderson disagreed, and in so doing, she distinguished a prior case where the Supreme Court had found that some aspect of the Alien Enemies Act involved a political question. In the 1948 case Ludica versus Watkins, which I apologize, I previously pronounced that as Ludecky, but in the Ludica case, the Supreme Court considered the habeas corpus petition of a German national detained under the Alien Enemies Act during World War II. Ludica claimed that because Germany had surrendered and there was a cessation of actual hostilities, the war was over and the Alien Enemies Act could no longer permit his detention. The Supreme Court had held that just because there was a ceasefire and the shooting had stopped did not mean the war was over. The determination of when a war actually ends is a political decision, which necessarily must be made by Congress or the president and not the courts. But Judge Henderson rejected the administration's claims that Ludica bars judicial review of all questions about the Alien Enemies Act authority. And Judge Henderson pointed out that the Ludica court had actually engaged in statutory interpretation by rejecting a narrower definition of declared war, which would have limited that phrase to situations where there were actual hostilities. As Judge Henderson put it, quote, Ludica did not foreclose courts' ability to interpret the Alien Enemies Act predicate acts, a declared war invasion or predatory incursion, or whether such conditions exist. Instead, Ludica stands for the proposition that when and by what means to end that acknowledged war are choices constitutionally committed to a coordinate political department. So having determined that the court has jurisdiction to consider the legal interpretation of the Alien Enemies Act, Judge Henderson turned to the government's arguments about the act's applicability. And she first considered the Trump administration's argument that there had been an invasion by a foreign government. Judge Henderson considered a variety of definitions of invasion, finding that within the context of the act, the word was meant to indicate a military invasion, not simply an unauthorized entry. She also discussed the historical context of the Alien Enemies Act, which was passed when a war with France was looming. A little over a month before the enactment of the Alien Enemies Act, Congress had authorized the president to raise a standing army of 10,000 men to combat a French invasion, but had only authorized the president to do so, quote, in the event of a declaration of war against the United States or of actual invasion of their territory by a foreign power, or of imminent danger of such invasion. Language that bears striking resemblance to the language of the Alien Enemies Act. Judge Henderson then summarized several other relevant discussions about invasions that were taking place at the time the Alien Enemies Act was passed. And all this context indicates that, as Judge Henderson put it, quote, an invasion is a military affair, not one of migration. And Judge Henderson found the administration's citation to the third definition of invasion in Black's Law Dictionary particularly specious, stating, quote, what evidence does the government muster against the weight of this evidence? It marshals a lone contemporary dictionary and then plucks the third order usage of the term after skipping over its many still more common military meaning. And Judge Henderson was similarly skeptical of the administration's claim that Tren de Aragua was staging a predatory incursion under the Alien Enemies Act, and not surprisingly found that incursion had a military meaning as well. So Judge Henderson concluded that the administration is unlikely to prevail on the merits of the case, though she explicitly left several important questions to the lower court, though, including the question about whether Tren de Aragua is actually affiliated with the Maduro government. She also rejected the administration's claim that the TRO would cause irreparable harm to the government. Judge pointed out the narrowness of Judge Boasberg's order. It does not prevent the government from detaining the plaintiffs or even deporting them. And if the government wanted to or wants to deport the plaintiffs, it simply had to go through the process laid out in the INA. And on the other hand, the plaintiffs' potential injuries, literal and figurative, were obviously significant. Judge Henderson stated, quote, lifting the injunctions risks exiling the plaintiffs to a land that is not their country of origin. She recounted how one plaintiff said he had been tortured with electric shocks and suffocation for demonstrating against the Venezuelan regime, and another stated that his family and counsel have lost all contact with him and have no information regarding his whereabouts or condition. And perhaps most disturbingly, Judge Henderson states that, quote, the government concedes it lacks a complete profile or even specific information about each individual it has targeted for summary removal. So Judge Henderson concluded that there was a strong public interest in preventing plaintiffs from being wrongly removed, especially to countries where they might face substantial harm, and that the government had failed to demonstrate a significant countervailing injury on its side. Thus, the government had not met its burden under the two factors. However, Judge Henderson did agree that the president could not be bound by the TRO, and she instructed the lower court to modify the TROs to exclude him. Now, this was a decision by a three-judge panel on the D.C. Circuit Court, and one of the other judges, Judge Patricia Millett, an Obama appointee, largely agreed with Judge Henderson's take, but in her concurrence, she emphasized the importance of due process, stating that, quote, the Constitution's demand of due process cannot be so easily thrown aside. The judge points out that immigrants are entitled to due process in their deportation proceedings, and that Congress had enacted a comprehensive legal scheme in the form of the Immigration and Nationality Act to balance the immigrants' need for due process against the government's need for sovereignty and security. And under the INA, even if someone has been deemed an alien terrorist, they are still entitled to notice and the opportunity to be heard in front of a neutral decision maker. And of course, it's quite ironic that Ludica, the German national discussed in the Supreme Court's 1948 opinion, not only received a hearing, but a hearing by the Supreme Court of the United States, despite being an ardent member of the Nazi Party, who once proclaimed about Hitler that, quote, his appeal to German manhood was like a call to arms, the gospel he preached, a sacred truth. And in her concurring opinion, Judge Millett was particularly critical of the apparent paradox presented in the government's arguments. The government was, on the one hand, arguing that the TRO was impeding its ability to exercise legitimate presidential power, while on the other hand arguing that Judge Boasberg's oral order doesn't actually bind the government. And the judge quipped, quote, "One thing that is not tolerable is for the government to seek from this court a stay of an order that the government at the very same time is telling the district court is not an order with which compliance was ever required. Heads the government wins, tails the district court loses is no way to obtain the exceptional relief of TRO stay." So the Trump administration, still seeking the power to continue its renditions, cut their losses and begged the Supreme Court to hear them out. But you can basically throw all of that out the window, because on March 28th, the Trump administration filed an emergency motion with the Supreme Court asking the court to vacate Judge Boasberg's orders. The administration again argued that the TRO is appealable despite the usual lack of appeal opportunities for TROs, and the Trump administration is also claiming that Judge Boasberg lacked authority to review the president's invocation of the Alien Enemies Act, and alternatively, the administration argued that even if Boasberg could review the president's use of the act, he was not empowered to grant a TRO regarding the entire larger class of plaintiffs. And on April 7th, the Supreme Court ruled on the Trump administration's emergency motion for a stay. Now, this decision is a complete mixed bag. I think it's mainly bad, but the good news is that the court agreed that, quote, "Today's order and per curiam confirm that the detainees subject to removal orders under the AEA are entitled to notice and opportunity to challenge their removal." So the court agreed that, quote, "Notice must be afforded within a reasonable time and in such a manner as to allow them to actually seek habeas relief in the proper venue before such removal occurs." So in a way, that's great. The court confirms that the president cannot remove someone from this country without any due process whatsoever and rendition them to a foreign country. I mean, you would think that that would be table stakes, but it's great that the Supreme Court has, in a unanimous decision, decided that that is in fact the case. But the bad news is that the court, in a unsigned per curiam opinion in a 5-4 ruling where Justice Amy Coney Barrett sided with the liberals, made it difficult or even impossible to actually obtain the relief as a practical matter. The Gang of Five, Justices Thomas, Roberts, Gorsuch, Kavanaugh, and Alito, vacated both of Judge Boasberg's TROs and proclaimed that the only relief the plaintiffs could obtain would be under habeas corpus. So the silver lining is that all 9 justices agreed that if the government kidnaps you and sends you to a foreign gulag, you are entitled to due process first before that occurs. Notice that you've been designated for deportation and a chance to contest your deportation confinement. However, the 5 men on the court seem to be willing to play along with the Trump administration's fecklessness because the habeas process does not seem like the right judicial remedy for people who are renditioned out of the country and held in a foreign labor camp. At the outset of the per curiam opinion, the 5 male justices accused the 4 female dissenters of being hysterical. Quote, "For all the rhetoric of the dissents, today's order and per curiam confirm that the detainees subject to removal orders under the AEA are entitled to notice and an opportunity to challenge their removal. The only question is which court will resolve that challenge." The per curiam opinion, meaning unsigned, so we don't know technically who wrote it, but it looks like a Thomas opinion, concludes that the plaintiffs must proceed individually rather than collectively, and they must file habeas corpus petitions in the district where they are confined. Of course, this edict completely ignores the fact that many of the JGG plaintiffs are not confined in the United States. And this is tricky because a habeas proceeding generally has to be filed in the jurisdiction where the person is confined. This is known as the District of Confinement. In a case called Rumsfeld versus Padilla, the Supreme Court ruled that the District of Confinement rule applies to, quote, "core habeas petitions challenging present physical confinement." But for years, the court expressly declined to decide whether habeas petitions filed by non-citizens, quote, "detained pending deportation," are this type of core challenge. Well, apparently the court has now resolved that issue without the benefit of full briefing and oral argument on the shadow docket by proclaiming that an individual's challenge to his removal under the Alien Enemies Act, quote, "falls within the core of the writ of habeas corpus and must therefore be filed where the plaintiffs are detained." Quote, "Challenges to removal under the AEA, a statute which largely precludes judicial review, must be brought in habeas, regardless of whether the detainees formally request release from confinement, because their claims for relief necessarily imply the invalidity of their confinement and removal under the AEA. Their claims fall within the core of the writ of habeas corpus and thus must be brought in habeas. For core habeas petitions, jurisdiction lies only in one district, the District of Confinement." Now you'll notice the specific language that the majority used, where they said, regardless of whether the detainees formally request release from their confinement. That's important here because these detainees are not requesting release from their confinement. They're simply asking for the normal immigration process. As the dissent points out, this is a dubious conclusion. Quote, "The plaintiffs in this case sued not to challenge their detention, but to protect themselves from summary deportation pursuant to the proclamation. Indeed, because all of the plaintiffs were already in immigration detention under other statutes when the government subjected them to the proclamation, they have repeatedly emphasized throughout this litigation that they do not seek release from custody and are not contesting the validity of their confinement or seeking to shorten its duration." And the Supreme Court's decision presents federal judges who will hear the habeas petitions with several dilemmas. They are supposed to review the habeas petitions filed by people who are not seeking the relief courts are accustomed to granting, which is release from confinement, When the plaintiffs file individual habeas petitions, they typically name the jailer or warden as a defendant, and the remedy that they seek is release from custody. But for the people who are in El Salvador, it's not even clear who the proper defendant would be because they're in the custody of a foreign government. So don't be surprised when the Trump administration argues that federal courts lack jurisdiction to hear the claims of people who were already deported. And if the Supreme Court eventually agrees with that interpretation, it means that Trump can defeat due process claims by spiriting people out of the country before the court can rule or in derogation of a court's order, which is what just happened to Judge Boasberg. And Justice Sotomayor's dissent calls this out, quote, "We all agree with the per curiam's command that the Fifth Amendment requires the government to afford plaintiffs notice after the date of this order that they are subject to removal under the Act, within reasonable time and in such manner as will allow them to actually seek habeas relief in the proper venue before the removal occurs. This means, of course, that the government cannot usher any detainees, including plaintiffs, onto planes in a shroud of secrecy as it did on March 15, 2025, nor can the government immediately resume removing individuals without notice upon vacatur of the TRO, as promised the DC Circuit it would do. To the extent the government removes even one individual without affording him notice and meaningful opportunity to file and pursue habeas relief, it does so in direct contravention of an edict by the United States Supreme Court." But at this point, it's crazy that the majority of the Supreme Court are taking the Trump administration at its word. The administration has already done things that the 9 justices claim it cannot do. The administration has exploited the habeas jurisdiction's requirement to play a shell game with detainees. And now, because of this ruling, quote, "detainees scattered across the country must each obtain counsel and file habeas petitions on their own accord without knowing whether they will remain in detention where they are arrested or be secretly transferred to an alternative location." And that's actually what's happening to Mahmoud Khalil, the Columbia grad student protester who was secreted away to a New York detention, then New Jersey, then Louisiana. And when his attorney attempted to file a habeas petition in New York after being led to believe he was there by ICE's own tracking website, the Trump administration moved to dismiss, claiming he had been moved so the New York court no longer had jurisdiction. Sotomayor's dissent acknowledges this, quote, "What if the government later determines that it sent one of these detainees to CCOT in error, or a court eventually decides that the president lacked authority under the Alien Enemies Act to declare that Trinidad is perpetrating or attempting an invasion against the territory of the United States? The government takes the position that even when it makes a mistake, it cannot retrieve individuals from the Salvadoran prisons to which it has sent them." And if you're watching the news, this is precisely the situation for Abrego Garcia. Justice Sotomayor also warns that the majority's decision applies with equal force to American citizens. Quote, "The implication of the government's position is that not only non-citizens, but also United States citizens could be taken off the streets and confined to foreign prisons with no opportunity for redress if judicial review is denied unlawfully before removal. History is no stranger to such lawless regimes, but this nation's system of laws is designed to prevent, not enable, their rise." Justice Jackson wrote separately to warn us that the case is analogous to Korematsu, the Japanese internment case, and potentially even worse. She says, quote, "The President of the United States has invoked a centuries-old wartime statute to whisk people away to a notoriously brutal foreign-run prison." So, because this is so serious, Jackson concludes that the courts need to allow the subject to be fully briefed. Quote, "When this court decides complex and monumental issues, it typically allows the lower courts to address those matters first. It then receives full briefing, hears oral argument, deliberates internally, and finally issues a reasoned opinion. Those standard processes may not always yield correct results, but when we deviate from them, the risk of error always substantially increases. At least when the court went off base in the past, it left a record so posterity could see how it went wrong. See, for example, Korematsu versus United States. With more and more of our most significant rulings taking place in the shadows of our emergency docket, today's court leaves less and less of a trace. But make no mistake, we are just as wrong now as we have been in the past, with similarly devastating consequences. It just seems we are now less willing to face it." So what's next for the Supreme Court? Well, they can't hide for long because they will be ruling on the Kilmar Abrego Garcia case, where the government admits that they erroneously deported a person who they shouldn't have. And once again, that decision will be on the shadow docket. And in light of the Supreme Court's holding in JGG, the best case scenario for the plaintiff and his fellow plaintiffs who are still in the United States is that they will likely be forced to litigate their habeas claims in Texas's Fifth Circuit, where they are purportedly being held, which is arguably the most Trump-sympathetic circuit in the country. And by shuffling the plaintiffs around very quickly at will, the administration can forum shop for a jurisdiction that takes a much less protective stance about due process, First Amendment, or any other legal issue that comes up. And the Fifth Circuit isn't even the worst case scenario for people removed under the Alien Enemies Act. The worst case scenario, and the most troubling legal question, is what happens to people like Mr. Abrego Garcia, who are already in El Salvador's torture prison. What court can hear their habeas petitions? But we'll likely get at least a portion of that answer when the Supreme Court rules on the Abrego-Garcia case in the coming days. But all may not be lost because a court in the Southern District of Texas wasted no time in granting a temporary restraining order on habeas grounds against deporting the JGG plaintiffs. So at least that's a step forward for the migrants who are still on American soil. But with the Trump administration's recent messaging that they will not grant visas to anyone who expresses a verboten belief about things like Gaza, now's probably the best time to increase your online privacy. And while total online privacy might not be possible, luckily there are people out there who can help, and that's why we recommend signing up for today's sponsor, Incogni. You can use my link in the description or the code LegalEagle for a 60% off discount. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too because Incogni fights back. These data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many spam calls lately, or even how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. I've been using Incogni for years, and in that time you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you, Incogni, for saving me hundreds of hours and adding me to over 40 suppression lists. And Incogni just launched a new feature called Custom Removals for subscribers to their unlimited plan that I think is amazing. It allows you to flag an unlimited number of sites where your data is exposed, and you can even have Incogni's privacy experts review and tackle the most uncooperative data brokers and people search sites. And Incogni will continue to conduct ongoing removals because even if the data broker removes your data once, they can always collect it again. So Incogni makes sure that your personal info stays off the market for good. So if online privacy is important to you, give Incogni a try. And if you click on the link that's on screen or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. But if you do decide to keep it, you'll still get the exclusive 60% off discount, so long as you use my link or the code LegalEagle, all one word, at checkout. So check out Incogni today, and after that, click on this link over here for more LegalEagle, or I'll see you in court.